Which one? Yes. What do you want? Oh, filing means nothing. You give it, it will be included in the monthly list.
Possible, my lord.
Something happens, then you come. Merely filing, it will not become urgent. Yes.
My
Give
lord,
it.
with the leave of Honorable Justice Vishwas, my lord, may I leave to mention one matter which was assigned to your lordship and the Honorable Justice Supratim Bhattacharya, and that it's a first appeal, my lord. So I have filed one application for early disposal of the appeal. I am the respondent decree holder. I am suffering with the pendency of the appeal. So kindly take up the matter, or my lord.
You are the appeal is you were not the plaintiff.
I am the decree holder.
Were you the
plaintiff? Respondent here.
Respondent. So there is no interim order.
Interim order, they have there is a stay, and I am suffering with the execution stay because of this.
It must have been put to some terms.
Pardon, my lord.
The stay must have been with some terms.
With a deposit of some amount,
So
but I am suffering with the because they are in possession of the property. That
mention in the new year. Wait for 2 weeks.
my lord.
Yes.
Yeah, my lord, kindly to mention a mandamus appeal arising out of the 6 matter, my lord. I have filed this preparative mandamus appeal challenging the order of direction of monthly cash compensation along with interest, my lord. Now the petitioners have filed a contempt application. That contempt application was heard on, my lord, on 5th of December, my lord, and the honorable judge has been pleased to hold that since the appeal has not been heard and there is one delay of 5 days in preferring the appeal, so he has been pleased to fix the matter
Go the order.
19th of December.
You filed an application for condoning the delay.
Yes, my lord.
Application you list Monday.
Lordship, I'm mentioning a stay application. Can one stay application? Respondent has already filed a contempt application. That's why I'm for the petitioner. I'm praying for stay application.
Arising out of a intra-court, it is intra-court appeal.
Lordship, I am not aware.
Mere filing of contempt, what is the problem? Unless the court takes cognizance of the issue, why? Let us see. Something happens, you come.
Lordship, grateful.
Lordship, may I be permitted to mention this matter for inclusion in the list, Lordship? The appeal matter, Lordship. Appeal, Lordship.
Yes.
The petitioner was suspended from his service in 2019.
Appeal from?
From a writ petition, Lordship, preferred by the petitioner in 2022, Lordship. And
Okay.
his prayer was turned down by the Honorable Court in 2024.
What was the issue in the writ petition?
Lordship, he was an employee of Mother Dairy, and then a disciplinary proceeding was initiated against him, and then he was suspended from his service.
So Mother Dairy, you filed a writ petition?
Lordship,
He was employee of Mother Dairy.
there
then
was a
why?
direction of rescind order to pass a rescind order to the director of the.
It's a cooperative. What is the Mother Dairy?
Lordship, I don't know, Lordship, actually.
You find out, come tomorrow. Yes.
Some analogous Group 6 appeal. Some urgencies because I could not serve the state authorities because due to illness of my clerk, I could not serve within the stipulated period upon the state authority. They will not now accept unless the court direct. So I am only praying a direction to serve upon the state authorities. Let it appear on the next month list. But this direction only to serve upon the state authority.
So earlier there was a direction.
No, the appearing was the first time. But before the listing date, we could not serve, but they will not now accept unless the court direct them.
What is the listing date?
Listing date was 5th
of December.
Yes, madam.
only direction to serve upon the state. Thereafter, let it appear in the next.
I am unable to understand why the direction is required if you want.
Otherwise, they will not accept. I have a talk with the government leader also, They said since the date has expired, we will not accept unless the court direct us.
What was the order? By which order it was posted for 5th December?
No, not order, while filing this appeal, we have given the date as 5th.
Oh, that date given by the department.
Yes,
What is it? Intra-court appeal?
Yes, intra-court appeal, regularization, against the regularization, one statutory authority is filing this appeal.
Who is filing?
Statutory authority.
There is a direction for regularization.
Yes.
Regularize him.
They are not entitled because they have, for them, they have separate scheme was framed.
Yes.
They will continue up to 60 years, they will get some benefits. That
Regularize.
scheme was framed for them.
Comply with the order. So what do you want? It will have to be taken up.
Only for direction. Let it appear as to be mentioned. Only for direction to serve upon the state. Thereafter, let it appear on the next.
No, I don't know why this direction is required. I'm not familiar with this practice. Therefore, I am asking. I don't know. I'm speaking for myself because I'm not familiar. Why a direction is required when a copy is being served on a government council? Why he will not receive?
Accepting. Since that 5th December has expired.
So you file it by saying that he has not accepted. What is the problem?
I have already filed it, my lord.
Then you file an affidavit saying that he has refused to accept.
Again, they direct me to serve, since they have not refused, my lord.
No, why we should take on this? I'm unable to understand.
The procedure, now the present.
Where is that procedure? Therefore, we are asking.
Following, no, there is no.
Then,
rules.
based on practice, if somebody is doing something, you are obliged to serve a copy.
My lord.
If they don't accept, you say they have refused to accept. Why the court should take up this that we will direct in every case the state government council to accept the copy?
We need support of the state government because ultimately the fund will be granted by the state.
We don't know. If they are not accepting, they will face the consequence. They should be accepting. Where is the requirement? Therefore, we are asking you, if there is a requirement, show us.
So there is no such rule.
Then no, you go and serve. You
procedure.
tell them, you inform them that on such and such date it is listed. If they don't come, it is their bad luck. You file an affidavit saying that they have refused to accept. You serve a copy of that affidavit on them.
Let this appeal be listed, my lord.
Listed, it will be included in the monthly list.
Okay.
Yes.
Let it.
Inclusion. Yes.
May I be permitted to mention one service matter under Group 6? Lordship, this is a compassionate appointment of the petitioner. The petitioner's land has been acquired by the respondent authority in the year of 2012.
Which authority?
Eastern Coalfield Limited.
Yes.
In the year of 2012, Lordship, I'm mentioning this matter for inclusion in the list.
Yes, give inclusion, you give.
Item number 1.
Yesterday wanted to see the 100 EMP.
Yes. It is in the WBSR. This one doesn't have.
And I have got 2 copies.
No. This is there. What is the date of that EMP?
13 March 1996.
ওয়েবসাইট থেকে বার করেছি আর স্পষ্ট ডাউনলোড হচ্ছে কিন্তু অস্পষ্ট
Page 526. In this book, it is at page 526.
Now, this circular has been struck down by a division bench or High Court.
Now they have already crossed that issue. That issue they have crossed.
But this judgment was delivered in 2005 by the division bench. But subsequently, 2006, Umadevi's judgment was delivered by the Supreme Court. Then, in 2010, division bench or High Court, relying upon Umadevi's judgment, declared to be ultra vires. And this point was available to them that our post service should be counted for the purpose of pension. Because 2008 regulation was made, joined in 2009 and retired in 2010.
My lord, moreover, the delay point
This has been declared ultra virus.
2000 online page 2017 corresponding to 2010 1 CLT page 187
2009 SCC online
online page 2017
201.
2017. Can you see paragraph 3 and last paragraph 9, the paragraph 10 and paragraph 11. Proposal will be the basis. ठीक ठीक है ठीक है
Yes, apart from that, now question of regularization is over. What is your other submission?
When the regularization was made or prayed before the Supreme Court, considering the age bar, this point was 2008 when they joined, they knew that they will attain the age of superannuation of 60 at a particular date. Everybody knows from 2008 or 2009 till 2017 they were waiting till the date of retirement. Just after retirement, after 7 years, filed the original application.
After retirement, original application was filed in 98.
No, filing the application for pension filed in 2017.
Obviously, you have from 2008, you have 98, you have dragged them for 10 years. In 2008, the absorption order was issued.
2008 absorption order was
2009.
no,
2010.
2008 order was 2005 order was passed by the division bench.
What is the date of retirement?
2010.
Date. We are asking the date, please.
Just one second.
No, 36, 2010. 30th June, 2010.
And original application filed in 2017.
For retired dues.
Result date.
What is the OA number?
OA number just please. OA number 375 of 2017.
My lord, he filed representation in the year 2010 on 36, 2010 at page 98 for pension.
Why you are waiting?
2010.
Why were you
And
waiting?
in the judgment also, in the case of my lord, Union of India and others versus Tarsim Singh.
Versus?
Union of India and others versus Tarsim Singh, reported in 2008, volume 8, SCC page 648. The Honorable Supreme Court, my lord, issued guidelines, and where there is a continuous injury due to continuous wrong, then delay should not be taken into account. More particularly in case of pension and scale of pay, court should not deny the application.
Tarsim
Because
Singh,
no
the,
third party right is a
in terms, Tarsim Singh, the apex court has
yes, my lord, third party right.
further elaborated in which cases it will not be considered a continuing wrong. Which paragraph? Both things have been issued.
Paragraph 7, my lord.
Where is that judgment?
2008 volume 8 SSC 648.
Yes. But does that mean you can wait for so many years? What kind of relief do you expect when you wait for?
My lord, moreover, my lord, 17, my right to regularization was crystallized on 3/8/1979 by 1700 EMP. Kindly see.
That's not an issue anymore. That issue concluded by your absorption in 2008.
Yes, my lord.
That issue is not, does not
But I
survive
was
in it.
appointed in the year 1975.
What is the
regular-
point in referring to 1975 and 1950? We are asking you why you waited for 8 years for claiming a pensionary due.
On
And
2000
because you have waited 8 years, what should be the result?
my lord, the account principal
You
accountant
shot off a
general
representation in
and the-
2010.
My lord, the principal accountant general rejected my case, my lord, on 22/4/2016. On 24, page 65.
Page
65.
Give
That
the
is on the
citation
24th.
Tarsem Singh judgment.
2008, volume 8,
Stop 100.
SEC,
Print out.
page 648.
And when the accountant general rejected the representation of 24th February 2016. Not
That was
2010.
advocate flood. We have approached many times. 648.
And in the case of Geeta Naskar,
Itanaskar also, my lord, your lordship dealt with the rules of my lord. In this case, my lord, I am not relying on the rules, but my lord, when the right to a regularization was crystallized, that is the main point. When you lordship dealt with in the Hiralal Ghosh, my lord, and on the basis of Supreme Court,
no, Hiralal Ghosh also, he had also come to the court after 7-8 years.
yes, my lord.
Let us
Yes,
see.
my lord.
Let us see.
But the rejection order, my lord, on 22/4/2016. Thereafter, I have filed, my lord.
That you have said. How many times you will say the same thing? We are
Sorry.
asking you to show Hiralal
Sorry,
Ghosh.
sorry.
Yes.
Sorry, my lord. In reply একটা আছে হিরালাল ঘোষ তো বার করতে হবে। Executive in
Yes, seniority and promotion. The exception was also specified in this judgment. That's what we were asking you.
Hilalal Ghosh also approached the court, my lord, on 1324 of 2016.
Where is the judgment? Hiralal Ghosh judgment.
My lord, my lord. My lord, page 30 of the reply.
Itanaskar is pending with us.
Hmm?
Itanaskar,
What is
Tally number 6381 of 2025.
diary number?
63818 of 2005.
Itanaskar is another department, my lord, and also
2025.
25.
in that case, no.
This is arising out of which case?
WPST.
That case, my lord, your lordship.
Please wait. Don't get impatient.
Huh?
Yes, which it is arising out of which case? 240 or 172?
Of engagement is.
Continue. Continue. Yeah.
40 of 2024.
So that is arising out of Geeta Naskar case.
Geeta Naskar.
Only covered. So no new objection is being raised by you. The same objection which was raised in Hiralal Ghosh. Same objection.
Kindly see. And he has rendered about 1 year, 3-4 months service.
6 months.
I mean, for the moment, 1 year and a half, 6 months. But under the rule 36, he must have a 10 years qualifying service. The court can consider you to conduct, count his past service, which was directed to be regularized in terms of the order passed in 2005.
So rule 36
Rule 36.
has to be read without reading rule 17 and 18.
Yes, and see rule 17 and 18.
Yes, let us see. DCRB, where is the DCR? DCR. DCR.
Qualifying service. Yes.
17, 18 and 22. These three rules.
3 rules.
Casual service for a period of 10 years culminating in regularization, then how the past service is to be treated. Let us see the rule.
Subject to the provision of this rule, qualifying service of a government servant shall commence from the date he takes charge of the office on which he is appointed, either substantive or officiating or in temporary capacity. Then, provided in case of officer in class 1, class 2 and class 3 services rendered before attaining the age of 18 or 6 years shall not be except on the compulsory ground. But that is not applied because he is a group D staff. Then, rule 18. Conditions for pension. Service or officer does not qualify for pension unless it is confirmed the following conditions. The following conditions, namely, service must be under the government. The employee must be substantive and permanent, or of permanent status or quasi-permanent. Service must be paid by the government. Then 21.
22.
22. So that specifies the qualifying service.
The officiating service of the government followed without any interruption by the confirmation by the declaration as quasi-permanent or permanently shut off in the same and another course shall however
Count in full as qualifying service.
work by service except
Then
the period of temporary official service in the assignment where contributed provident funds benefits are allowed shall not count unless government contribution include refunded. Has he returned?
hmm,
There must be some contribution in the service in a provident fund.
can he hold on to it if he wants pension?
No,
If he has been paid, can he hold on to it?
no. First, whether he has contributed or not.
Where is that? That's not a prerequisite.
Want to consider the language?
Yes.
The period of service paid from the contingency shall not count.
Yes.
Small b.
Unless it is refunded, not unless it is received.
And any.
So if he has received, then only he will refund. It does not say unless received.
Here there is no contribution. Pension comes from where? From the rendering service?
Pension comes from where? From the GPF amount.
No.
Then
Pension.
how pension is dependent on GPF?
The pensions when he render services.
That is a recognition of past service. The law
Recognition
is very well settled. Where is the question of it being linked with GPF?
What a Kalishi, 2008 or 2009 order was passed.
No, therefore we are saying those objections we have dealt with in Hiralal Ghosh. I am author of that judgment, so therefore I remember. These objections are the same. There is no new objection raised by you. Here only the difference is that his post-absorption service is very minuscule. Now, because you have delayed in absorbing him for decades, then he should be made to suffer.
No, unless the matter is settled by the court or final order is passed by the court, but according to the circular, they are not. What are the interpretation given by the court? We have accepted it and regularized in service in 2008, and he joined in 2009. He retired in 2010.
All right.
After that,
That's all. But the parties list under the Okay. We'll see.
Yes, please. My lord, Kartik Chandra Das, my lord, more than 6 years has been, my lord, condoned, my lord,
In
which is in Kartik Chandra Das, who was an organizer teacher. My lord, more than 6 years was condoned, not on the basis of the rule, and Supreme Court affirmed that judgment. Division bench affirmed that judgment. If your lordship can
give,
yes, my lord.
we have given him a copy.
Yes.
We have given the.
He knows, my lord. He knows.
He knows everything, but still you have to give him a copy. He is appearing in all the cases. That does not mean you will not give him a copy.
Knows everything, my lord.
no.
My learned
Put it in the file. Yes.
No.
Very often he is clarifying things for us also. He knows everything. That's the
very little
advantage of
knowledge.
having the experience.
But a very little knowledge.
No. That is
Must
modesty.
decide, my lord.
Yes. But modesty is good. Yes. Call the next case.
Grateful, my lord.
Item number 2.
Item 2, my lord, IFA for the petitioner. আপনি আছেন? This is the affidavit of service, my lord. I've served all the respondents. Now, my lord, the issue of the petition this case is, my lord, the same. A doctor tendering resignation has been rejected on the ground of dearth of doctors. But same old story, time and again, has been repeated by the authorities. Now, my lord, if your lordship takes up the rejection order, the rejection order is at page 41.
Before we proceed any further, you are appearing. We were informed the other day when this batch of matters was taken up that perhaps some recruitment is finalized.
My lord, only difference in this matter and those matters maybe, my lord, this petitioner, my lord, is of West Bengal Health Service. And those are, my lord, from West Bengal Medical Education Service. Only difference is this. Health department remains the same, my lord, there are two directorates. Now, my lord, in this case, what has happened, my lord, hardly any matters with regard to health services was came before your lordship. But in this case also, issue is, we said that the higher authorities have rejected your resignation, so nothing can be done. If your lordship takes up the rejection once, at page 41.
No, so all right, you want to resign for?
I want to
Is there any, have you stated any reason or?
Yes, my lord.
you are
My
just-
health and my lord, my other reasons, my lord, I want to resign from service, my lord, and my lord, your lordship takes up the resignation, my lord, that is also.
No, you are not obliged to. We are just asking you
Yes, my lord, I've stated the reasons.
whether you have said, what is your case because of poor health?
My lord, my health is deteriorating, my lord. I do not want to continue any further. And I'm being transferred to my far-flung place. My lord, this is also there in the resignation. So, my lord, I cannot continue with it. My lord, page 40, what is it? Resignation order. It says, my lord, in connection with the above mentioned subject and reference, I am directed to inform you that your prayer for resignation from West Bengal Health Service with effect from 22/2/2025 has been rejected by the higher authorities considering the dearth of specialist medical officers in health service, and you are asked to continue service with the government. Well, this very issue has been dealt with by several coordinate benches and by your lordship, my lord. And in no unclear terms, there is no ambiguity, my lord. It's no more res integra. Still, my lord, same thing has been taken out. And my lord,
Yes, Mr. Mukherjee.
paragraph 10 of your lordship judgment, from paragraph 10 onwards of your lordship judgments makes things absolutely clear. But there's no ambiguity whatsoever. But only thing they can do, my lord, if there is a shortfall of notice, they can ask for my salary for that period. Nothing more they can do. But still they are insisting on.
For which period?
Now, if there is a, in this case, I do not know, but if there is a notice, shortfall of notice, well, they can ask for the, well, in lieu of.
What is the notice period? 30
well,
days?
It's 3 months. It's
3 months.
I'm
So when did you apply?
Lord, I applied, my lord, on. I've applied on, my lord,
28 January 2025.
and my lord, I applied on 28th of January 2025. My lord, I asked for resignation from 28 to 2025. My lord, so even if I assume there is a shortfall of 2 months, my lord, what the best set can do, my lord, they can ask for the.
Which is the provision? Let us see.
My lord, the rules say your lordship in the lordship's order. If your lordship takes up your lordship's order, that makes it clear.
It is quoted.
Yes, my lord. It's been quoted and, my lord, it has been dealt with by your lordship.
No, where is the? We just want to see the rule. We
Yes, my
remember.
lord. My rule 34A1.
It must have been quoted in the order.
Rule
34A1.
Yes, page 46
Yes, my lord.
of your
That
brief.
rule has been quoted by your lordship.
বাবা ভুলটা বার করো না এখানে কি ওখানে থেকে হবে না, এখান থেকে বার করতে হবে। A1
So 34A2.
Yes, please, ma'am.
How you justify such orders being passed?
মানে kindly another aspect মানে page মানে 36 for a moment, sorry 39. He got MBBS degree at the cost of the state as a
Mhm.
student in a government medical college in 1996. Then Malada DGU in 2001 from the state government, and Malada MS Master of Surgery in 2016 as a state government employee. মানে we are paying about 30 lakh per student per year from the state exchequer. Now, after getting all these things, no, I will not work with you. Kindly consider this aspect. I will not say anything more.
So you have paid for his study. That means what?
No, we are.
He must have executed a bond.
No, we expecting.
He must have executed a bond.
No. He will render service 3 years.
He must have executed a bond.
At least 3
So
years.
once that bond is over, then what remains?
Sir, what expectation for?
This is a reason assigned.
No. This is
Then
reason that now
you see the reason which has been assigned.
I see that this specialist doctor is not available.
Then that's why we are asking you, how do you justify this order? This is futile litigation at the public cost. 4 judgments we have recorded in that judgment which we have passed. In one case, you have been saddled with 50,000 rupees cost for taking such a stand. Still, you are taking such a stand.
Page 35 for
Then maybe it is time now that the officer should bear the consequence instead of the state bearing the consequence.
for Balafadi actions, we had that. We want a doctor, nothing more.
Point is, you may want many things, but can you have it? You may want many things, but can you have it?
No, certainly not. But we expect
Your desire does not justify the action. You are a state authority, you have to act in conformity with the rules. You don't have unbridled power. No authority has an unbridled power. So just because your desire, therefore you will pass an order.
What desire is, kindly consider very limited purpose. Government.
Can you justify? We are asking you. We have read what he has said. You have assailed this, you have pursued this point up to the apex court. You have lost up to the apex court, trying to pursue the same desire. Now, is it open to you to pursue that desire again?
No.
In every case that comes before you.
That with regard to the All India Institute of Medical Science, that's all. But here.
What All India Institute? There also there was dearth of doctors. Forget about All India Institute. That is not a distinguishing feature. Then that is not a distinguishing feature. There is no distinguishing feature. Every day the same order is being passed. And your officer is passing the order and contesting the litigation at public cost. Should he be allowed to do this? Who is this officer who has passed the order?
Deputy Director of Health Services. Mostly with the consent of the secretary. Without the consent of the secretary.
I think we should include him as a party.
Psychology is also there.
No. This is going too far. Now this is going too far.
On that, I think that the doctor should be there.
Therefore, we are saying your desire will not rule. The service rules will prevail over your desire and over the desire of the employee. Your desire will not prevail. How you can do this?
This is an admitted position there, we are not of specialist. This is an admitted position.
That is not an issue before us, whether there is a dearth of doctor, why there is a dearth of doctors, whether you are advertising, if you are advertising, why people are not joining, whether you are not advertising, we don't know. That's not the issue before us. Issue is there is a rule providing a right in a government servant. You cannot compel a government servant to continue in employment for your desire. How many times should we pass the same order? Now that is the only issue. How many times the court should pass the same order, and a litigation should be contested on the same point repeatedly at the cost of public exchequer for the desire of the authority.
I have not received the instruction, just have received the brief. I've seen that order passed by your lordship and the order passed by the authority concerned. And he will, I think my lord will lose his pension and other benefits.
Yes, my lord, I'm willing to forego, my lord. I'm not saying I'm.
You think he doesn't know? When he's tendering a resignation, he doesn't know that he will lose everything. We don't know. He may have greener pastures, whatever is his reason. We don't know. That's not the point. He's not required to.
Accepted any proceeding is pending or inquiry is pending, that
Nothing. You have not said anything.
only the task of medical officer. I leave it to the court, my lord. I go since I put the matter.
You know the entire background. You know how the matter has been decided repeatedly, and you know that in one case it has occasioned a cost of rupees 50,000. The point is you did not file a reply after the tribunal he has come here. So we are giving you, no, after approaching the tribunal he has come here. So we are giving you, obliged to give you one opportunity. We hope that better sense prevails. Otherwise, we'll pass any order that we consider appropriate. An issue arising for consideration in
Expose that. 3 weeks. Top of
After 3 weeks, top of the
that is tax eligible.
need it.
তেরোই জানুয়ারি 13 jan
বাপরে পড়ে গেল
নাম পেয়েছিস
হ্যাঁ।
আইটেম নাম্বার 3
on behalf of petitioner lordship. Petitioner joined his service lordship on 8th July 2000 and 1978, 1978 as a constable with branch number DAP 1257 under the then undivided Part 1 District Police Force, West Bengal, presently Commissioner of Police, Asasol Durgapur Commissioner, respondent number 7 herein. And lordship, he discharged his duty sincerely and diligently. That on 2nd August 1986, the petitioner was placed under suspension lordship by an order dated 1139 of 4/8/1986 with effect from 2/8/1986 issued by the office of the then Superintendent of Police, Part 1, following his implication in a criminal case, running as PS case number 2 of 1986, dated 2nd August 1986. And lordship,
Yes, why did you not join after 2003?
lordship,
Why did you not join after
lordship,
2003?
the order is never communicated to me, lordship, never. The service proceeding never comment. No order is
Let us see what you have said in your OA. Come to your OA. Where is your OA?
lordship. Where is page 87 of course.
Hmm. Yes, what can be done?
Lordship, kindly you find page 124, Lordship. Page 124, Lordship.
What is
Departmental proceeding has been served on 26th July 2023, when I am already superintendent, Lordship. But I'm already superintendent. Never departmental proceeding, withdrawal of suspension, and also another order for transferring order, Lordship, page 120.
this is not addressed to you. Why you are referring to this?
I have no knowledge during filing the way
Why you are showing page 124? What do you want to show?
it is served upon me during the
Where it is served upon you? Show this letter is addressed to whom?
officer in charge Gopal Nagar serving.
This is not you.
Yes, upon me.
No,
Lordship.
this is upon the officer in charge.
Huh?
This is not served on you. You are not the officer in charge. You are a
No, I am
constable.
constable. This officer in charge serving upon me. This letter.
How do you say that? You are reading a document and still you are making such submission. It is not addressed to you. How can you say it was served on you?
It is given to my house, Lordship, the petitioner house, Lordship, this copy.
A letter addressed to the officer in charge is given to your house.
Yes, Lordship. This is officer in charge Gopal Nagar PS, one officer of this PS going to my house and serving this letter, Lordship. Because I am residing another jurisdiction of police station, Lordship.
Anyway, after 86, you never joined.
ITCs I am suspended, Lordship.
After 86, you never joined.
I am 2023, my suspension order withdrawal, Lordship.
After 86, you never joined.
Lordship.
You were released after you were arrested. You were wreleased on bail. Then were you required to go and join, or you were not required to go and join?
Lordship, I am acquitted on 2013.
Again, we are asking you. You were released on bail in 1986. At that time, were you obliged to go and join your posting, or you are not obliged to go and join?
At that period, I am in suspension. And no substitution allowance also given to me, Lordship.
You were not required to join.
No, I'm not at the period of I'm suspended, Lordship.
So you are not required to join. Suspension is because of being in custody. The moment you are out, you are supposed to inform. That is the rule. You don't know anything. You are sleeping for decades and all of a sudden you want pension. Wonderful. What is wrong with the tribunal's order? Nothing is wrong.
Lordship, yes, after acquittal, Lordship, suspension period treated as on service, Lordship.
Nothing, sir.
Next to 2003, I am.
You are not diligent
There
for
is
your own
judgment,
right.
Lordship, this honorable court, Lordship, there is judgments. Justice
Nothing.
Sanjeev Banerjee division bench, Lordship.
Nothing, sir.
After acquittal, the period of suspension treated to be in service, Lordship.
Yes.
Lordship. So 1986 to 2003.
You have chosen not to discharge a single day's duty after you were released on bail. You have taken no steps. You could have gone and joined. The service rule provides that once you are placed under arrest, you will be, there is a deemed suspension. That is a standard provision in all the service rules. After you are released, you have to go back to the employer. They take a decision to continue on suspension. They may take a decision to take you back, whatever. You have done nothing. After 86, God knows where you were, what you were thinking. And now all of a sudden you have short off letters and you say, give me a pension. How it can be done? Cannot be done.
Lordship, period of suspension may be regularized. When I acquitted from criminal charge, Lordship, there is a division bench order, Lordship.
Yes, for someone who never goes to the authority, show the division bench judgment.
Today's not, I have.
Then forget it. Don't make submission like that. We understand what you are saying. Once you are acquitted, you are entitled to. But what steps you have taken, we are asking you. You didn't know that you were acquitted. That order was not served on you. Acquittal order was not served on you.
Service, I have, Lordship.
Acquittal must have been recorded in your presence.
yes,
What did you do after acquittal? 2003 you were acquitted. 86 you were released on bail. After 86 you didn't join. After acquittal in 2003 you didn't join.
No,
In
sir,
2016,
I am a long period of time in custody,
No,
Lordship.
86 you were released, sir. If you bother to go through your brief, you will realize. What is the date of his release on bail? 14 December 86.
Seven.
Where is that? Which page?
I have got instruction from my.
No, you have filed a reply in the tribunal also. You must have said in the reply.
In reply, my lord, page 111. Page 100. First paragraph. Towards the end of that paragraph. So he was
14, 12, 87. Yes.
and he didn't turn up, abandoned.
After that also he didn't join. So he has worked for about 7 years, 4 months total. You are responsible for your plight. What can anyone do?
Lordship can accommodate 1 week, Lordship, I can show the judgment, so 1 week accommodation, Lordship.
Tomorrow you may come with the judgment if you want.
I show you the large judgment, Lordship. can
Not
be
later than tomorrow. All right, come on Monday.
Okay.
The short facts arising for
Want to frustrate the proceeding? Yeah, joined.
Item number 4.
Four, my lord, I appear on behalf of the state. May I request your lordship to take up the matter? It is after my lord, but I will take.
What is the issue?
Compassionate upon.
Rejected.
Rejected, my lord. My lord, may I?
Him place his case.
Not. My lord, I don't think, my lord, your lordship needs to, my lord, going to the order of the tribunal, considering which the result order was passed. If your lordship kindly takes up, my lord,
It is pending before the trial.
but the reason order was questioned before the tribunal. Now there is no judge. So, my lord, the tribunal has fixed the matter, my lord, in March.
When you did not appear.
No.
Please read the order.
My lord, it is before the registrar.
Please read the orders.
I have read.
Yes, none appears.
The registrar has no power to
Anyway,
fix any order.
there is no urgency. It can be
But-
considered.
This is second time.
Maybe
But can you hear me for 2 minutes?
more than 2 minutes.
Well, I'm so glad.
Yes. We
Comrade,
give you 7 minutes.
Well,
Yes.
time start now.
Time starts now.
Now, my father expired while in service. On 9th of February 20.
Can we go to the recent order?
Before.
That will unravel the entire sequence of.
See, it is required. Why I start from page 1? It is required.
Yes.
Kindly give me 7 minutes.
Yes. Sorry to interrupt.
My father expired in 2013, 9th February. Immediately thereafter, we on 9th of March, I made the application. The application was processed.
Son.
No, daughter. Married daughter. Now the application was processed on 23rd of June 2014 for the first time. The block development officer of the said block has requested the assistant engineer to go into the details of the application. Thereafter, in 2015 also, the executive engineer is writing regarding the inquiry process to the petitioner. 10th of February 2015, that there will be an inquiry done. Now, your lordship kindly turns to page 42. There is an interdepartmental correspondence, which is very important. Page 42. Writing, the letter is written by the executive engineer to the superintending engineer regarding the proposal for appointment on compassionate ground. Now, the applications and other documents were placed before the superintending engineer. But no decision was taken. I approached the tribunal. Your lordship kindly have a look to. Before going to the tribunal's order, kindly takes my endeavor. I approach the authorities 112 page by writing, seeking information under the RTI. What is the fate of my application?
The deceased did not leave behind a wife.
Yes.
She was not eligible.
No. Now, the decision has come in 2024 in reply to my RTI application that 3-man inquiry committee was done. The committee submitted the report. If your lordship kindly takes up page 112.
Yes.
The final decision has not been received. So, since 2013 to 2024, the department was sitting tight. They did not take the final decision. Kindly turns to 113.
Yes.
The inquiry report. The comments of the inquiry committee. The monthly income of the family as shown in the sheet, which is fall below 90% of the alleged gross salary of the deceased. The 3-man screening committee inquired about the application dated so and found that all 3 daughters were married while deceased was alive. Now, Srimati Shondharani Bose, wife of the deceased, aged about 55, and she is very ill and also lost her 1 kidney, so and so. Srimati Manashi Bose, the petitioner before your lordship, married daughter of so and so, will look after her mother. The family members are demanding for a government service
on compassionate ground, the inquiry committee is hereby submitting their demand for service to the higher authority for sympathetic ground if prevailing government rules and order permits. Now, in spite of this report, nothing happened. I approached the tribunal.
What is the date of this committee's
That
recommendation?
the inquiry report is of 17th of February 2015. From this report, the eligibility question was taken into consideration by the inquiry committee. Now, your lordship turns to the order of the tribunal on 19th of page 136. On 19th of February 2025, the tribunal directed the department to pass the reasoned order. Now, your lordship turns to the reasoned order. 138. Like that. Affidavit of service. Compassionate appointment. Twenty 2013. বলেছিলাম আমার নাম আছে এই সাউ অনেকটা সাউ হ্যাঁ 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 নিয়ে the additional chief secretary has mentioned regarding the notification of 251 EMP. Your lordship, kindly have a look.
No, no, we are asking you why High Court? When you have approached the tribunal, why High Court? We are not on the merits of the matter. You have given the background, we have seen it. Why the High Court?
Why High Court? Well, there is no judge in the tribunal.
That we know. You have just approached the tribunal in November. Did you
Yes.
think it would be decided by December?
No.
Then
Well, the first
will
date
be
has
done.
been given in April.
It will be done.
Well, your lordship, kindly.
It's a normal thing. It's not
No,
something
this is not
unusual.
normal thing. Well, I am searching for this job since 2013. Today, I am in 2026
All right.
practically. The lordship kindly sees for last 13 years, I am waiting for this job.
Correct. What can be done?
But kindly do not shut me out. Kindly.
Not before this forum. We don't want to express any opinion at the moment. You just filed it in November and you have come here because the tribunal is vacant.
No. I have approached the tribunal. The tribunal did not go into the merit of the case, send the matter direct to the department for consideration.
After that, you approach the High Court also.
No.
Yes.
But
After that, the division bench has also applied its mind to that order of the tribunal. And that order is not before us today. Today is your invocation of the tribunal's jurisdiction in OS 603 of 25, just in November.
True.
Now, after filing that, you have straight away come here as if we are to decide instead of the tribunal. That is the only thing we are asking.
Your lordship kindly see, kindly concentrate on the grievance of the petitioner.
No, that comes later, only after whether we are to
If
entertain
there
it.
is no judge over there,
Therefore, we are saying there may not be today, but you have just filed. It's not that you have been waiting there and all. It's
for
not.
last 3, 4, 5 months there is no judge.
You filed in November, sir. You have filed this case in
Your
November.
lordship, my lord has the vast experience of dealing with
We
these
are
matters.
not going to open the.
There were only one judge, administrative officer.
Still, it was being decided. Still, it was being decided, and you have also come in many cases.
Many cases.
So therefore,
But
not
kindly,
before this court.
then may I come after vacation?
No, no, no. Sorry, you go before.
Kindly, your lordship, kindly, your lordship, kindly. Please, I request your lordship. I request your lordship.
Every lawyer will request this. Nothing new.
Kindly,
It's for us to decide.
absolutely, but I am not on that. But the case is, what will be the fate if the
You have already said that you have been pursuing the matter since about a decade. You are saying that it is case of compassionate appointment, and you are saying that there is no judge. These are
there
is no judge today in the tribunal.
No. I don't know when the judge will be appointed.
Nobody knows. But then immediately after filing, can you come here? We'll consider. Lord Learned Advocate for the
I am for the petitioner. Page 69, order passed by the learned tribunal.
Yeah.
My lord, here in the instant case, page 70, my lord, 2 or 3 line, department referred the matter for views of the Labor Department on 4th August 2015. The Labor Department responded with its opinion that employment on compassionate ground cannot be transferred to any other person. My lord, that is, my lord, incorrect, my lord, that 2015 August 4, that was not supplied to me. But no, page 70. Page 70, order passed by the learned tribunal, the department referred the matter for views of the Labor Department on 4th August 2015. The Labor Department responded with the opinion that.
Where is your request for transfer of the employment?
But no, never, my lord, what has happened?
Where is your request? Where is your request?
My lord, my request, my lord, my lord, if your lordship kindly have a look into page 44, last request. And thereafter page 46. Page 44, my
Where
request.
is your first request?
My lord, first request on behalf of me, that is page 33.
No, the
As
first,
per,
please listen to us, then respond.
my lord,
We are asking you, where is your request that it has to be given to your daughter instead of you?
my lord, that is page 44.
43.
Page 44. First request. 43 and 44. And page 46, my lord, state offered, my lord, kindly have a look into to the present petitioner, page 46, kindly have a look into page 46, inquiry appraised, and no reason order was passed by the department till now. My lord, page 46, kindly have a look into page 46, my lord. Pro forma was offered to the petitioner, the daughter. Page
Why not?
46.
Every applicant will be given a pro forma. That does not mean anything.
And not only that, nowhere, my lord, mother was selected, appointed as, my lord.
Mother has herself said that I was selected.
My lord,
That is why we wanted to see your first application.
First application.
We
my
thought
lord,
that it would be there in the
my lord,
application.
due to overage, kindly have a look
Please
into page
read.
43.
Please read.
I, Timothy Maya Sarkar, that in unnamed category on such and such. Later on, I provisionally
Provisionally
selected.
selected. What is it?
My lord,
What more?
thereafter, lordship kindly, under the directorate such as due to overage.
Yes.
Due
What
to-
overage?
Due to overage, that time I am 47 years old.
So, if they are willing to appoint you, what is
That
your
is, my
problem?
lord, not selected, my lord. Kindly have a look into that later.
No, you
Kindly
have
come to,
you have yourself said that you were selected.
kindly come to, my lord,
Paragraph 12.
kindly have a look into page 42. My lord, kindly come to page 40. Call letter for appearing in eligibility test.
No,
Page
that is
40.
nothing. We want
Kindly
to.
come to page 40. Kindly come to page 40, my lord.
No, sir. Show us 8/10/2007 letter.
10/10/2007 letter.
8/10/2007 letter.
My lord, page 39. Provisionally has been selected provisionally in the post of.
Then what remains?
Thereafter, my lord, in the eligibility test, my lord, petitioner failed. The mother failed.
No,
in
no.
eligibility
There
test.
is no eligibility test after this.
My lord, kindly come to page 40, my lord. Kindly come to page 40.
Yes.
Call letter for appearing in eligibility test for different post of fire operator staff. Page 40 and 41, name of the post, assisting mobilizing officer. Page 41 in the middle portion. It is relevant to mention in this contest. It is an eligibility test for consideration of appointment to the post of fire operator, such and such, and the candidate qualifying the eligibility test will be asked to appear at endurance, written test and viva voice in such and such.
What happened after this letter at page 39?
Page 39, my lord, no appointment letter was.
Show from your OA what have you stated about this. After 39, what happened? Show us from your OA. Don't
My
just
lord.
make submission like that. What is your client's case we want to see?
My lord,
My mother
my lord,
passed away. I was myself sick.
page 39, my lord, page 39, my lord.
Come to the OA. Let us see what
Come
is.
to the way page, my lord, page 57 or 56 onward.
Yes.
56 onward. On the day our mother along with applicant, my lord, 58, Roman 7. Your applicant states that on the day our mother along with the applicant physically appeared to the said office, and on that day, on dated 15 December 2011, applicant's mother had prayed before the Directorate General West Bengal Fire Service to provide service. Her daughter who is present applicant and concerned authority considered the said prayer. Your applicant
Where
states
have,
that
in which paragraph you have stated about this letter of 10/8/2007?
2007,
We are looking at your OA. We
wait,
are,
my lord.
yes.
And my lord, in the way, my lord,
Change.
my lord, change brief, my lord, nothing has been written, my lord, in the way, my lord. With due respect, I am submitting before your lordship, my lord.
So that is the case the tribunal has decided. We have to see whether the tribunal has decided correctly or not. Not on the basis of pleading in the writ petition, but on the basis of pleading in the OA.
Yes, my lord, way, nothing has been stated, my lord.
In my representation, I have stated. The petitioner has stated. Mother-in-law, she had
2007 and letter 39. 43.
আমার mother-in-law তখন মারা গেছিল। 2014 লেটারে তো তোমার
But I have stated my serial number is 47 out of 266. Daughter serial number.
Not daughters. Is your mother's?
No, no. Page 45.
Yes, then after this letter of 8/10/2007, she was not appointed
No, she was already selected.
provisionally. She was selected provisionally,
Provision.
but not appointed.
Not appointed.
Then again, her claim was being processed for this other post in 2009.
2009, my lord, possibly the daughter was also underage.
No. 2009, her claim was being considered for another post. That means till then she was not offered any appointment.
Get fully.
So what happened after this 13/11/2009? What happened after 13/11?
Page 40.
So it was not granted. No, just tell us. There is no order finally giving her an appointment. Where is that? On which date?
Document is with me.
Where is that? No, that we say that is there in the page 42.
Get fully.
It was 8 years when the father died.
That is not the point. So it is still being processed. By then she has attained eligibility, and the mother does not want to continue because she has crossed the age. You file a opposition, we will consider.
Obliged to your notice.
The petition.
No, 26 EMP of March 2016 that says that pending applications will have to be governed by that 26 EMP. And in that there is a provision that if nobody is qualified, so let us see this short submission advanced on behalf of the
Item number 6.
Father was working under the sericulture. Now it is converted to agriculture.
was working in
My father was working under the Department of Sericulture. Now it is converted to agriculture.
sericulture.
Sericulture. Now it is converted to agriculture. During his course of employment, he has died on 2nd of February 2010. 2nd of February 2010. Thereafter, my lord, after the death of my father, I have made application on the 21st of July 2010. Actually, can you come to page 51 and 52?
Yes. So thereafter, what happened?
My lord, when I was studying in my lord higher secondary course.
When you applied, when you had applied
When
at the time of your application.
application and appeared by within the 6 months. My lord, when I was studying class 12, that is higher secondary, my lord, thereafter, my lord, my mother applied. My mother applied for commission appointment for her. And because on that time the examination was knocking the door, for that reason my mother was applied. And the lordship come to my mother application. Lordship, can you come to page 55?
Yes.
55 and 55. Application.
What has been done? Your mother applied because you were not eligible.
No, I am eligible.
So both have applied.
Study the higher education.
So there are two applicants.
No, applicants. My application is pending there.
So there are two applicants. You and your mother both.
During the pendency of my application.
Don't say no. There are two applicants. So what happened? Tell us.
My lord, my mother made application, and that is two applications.
Then what happened? Tell us. Yes.
My mother's application was considered and rejected. Rejected on, my lord, 2nd of August 2016.
Yes.
22nd April 2015.
27th April.
2nd April 2015.
Yes.
Yes, 58 lordship can be counted.
Yes. Then what happened?
Lordship. But, my lord, lordship kindly, 1 minute, lordship kindly come to page 58.
No, you are here for your own appointment.
14A, rule 14A, lordship kindly rejected on the ground of.
Are you here to espouse the cause of your mother, or you are here for your own appointment?
After the rejection of my mother's application, on 22nd of April 2015, my lord, thereafter my mother again made an application. On my lord, 2nd of August 2016 for consideration of my application. When I have filed on 21st July 2010, my mother, after rejection of my mother's application, my mother further made application for consideration my application.
Yes. Then that has been rejected. Where is the rejection order?
Lordship, kindly come to 28 June 2024. Lordship, kindly come to page 88.
Where is the rejection order?
Page 88. Dated 20th June 2024. My application, the very first within 6 months, my lord, I have applied. That was rejected on page 88. Consideration. My mother applied recommendation for my application, which I have filed on 21st of July 2010. Not instead. The application, the last part, one paragraph, their application already withdrawn by Sri Abhinav or that is the petitioner, but not at all withdrawn.
And why the mother's application was rejected? What is the ground?
Second come to page 58. You can come to page 58. Page 50. Thereafter, kindly come to page 65. Para 14A. The relevant circular I have annexed. Can come to page 65. 65 is my lord. All the departments will furnish number of the 14A undisposed case in the pro forma at Annex B within 15 days from the date of issue of this issue and submit the same in every year by 15th of January of the concerned year. Application submitted more than 2 years after the death or incapacitation prior to issue of notification number 30 EMP dated 2nd of April 2008 will not be entertained. My lord, I have submitted application with the limitation period that is of my lord, I filed application of my father died on 2nd of February 2008 and I made application 21st of July 2010. And mother's application is my lord 10th May 2011. That is within the 2 years. Nor my mother's application has been considered and both applications are accepted. And I am the financial distress condition and it is my lord, a copy of the
Why you did
my mother logically was one name logically 98. The certificate issued by the office of the district magistrate and collector Murshidabad.
Who has said you are not dependent? Who has said you are not dependent? Has anybody said that you are not dependent?
The order of the rejection.
Let us see. Page?
Page 88.
Yes. Where does it say not dependent?
Hello. The last but one paragraph ED.
Yes.
First, their application already withdrawn. Never withdrawn.
Where it says not dependent.
By Sri Abhinav Roy, the dependent edition. Abhinav Dev, for perusing his higher studies, and he does not establish the need of immediate financial assistance to get relief from financial distress as mentioned in clause 6A of the Department Notification of Authority.
I have a problem, sir. 15 of mother's application was rejected. 20, 22, 4, 15, whatever it is, that was not pursued. 22, 4, 2015, that was rejected. You have tried that consider. Your mother did not challenge her rejection.
No, mother did not challenge. Because mother rejected. But the different subsequent after rejection of my mother's application, mother made an application for her son. My son has made application in 6 months from my husband's death.
Where has she said that in her application? That application was filed within 6 months?
I filed the within 6 months.
Sir, we are,
2 years.
when you make a submission, we expect that it should be borne from the document. You said that she has applied, that the son had applied. She has not said anything like that. She has said, I was not selected, now consider my son. Is there any scope to do that?
Right.
Under which provision? Then the second son can come that now he has not been appointed. You can.
Only one son.
So why not second?
Only one.
Why not second? If there is a second son, then second son can come. Is there any provision that repeated application can be made? Is there any provision for repeated application?
My application, the application made on 21st of July 2010, that is still pending.
No, it is not pending.
Not considered.
That is not pending.
Rejected, not.
Where is your mother's application? First application, which was processed.
Page 55.
Yes, 55. My lord.
Yes, so there is no application.
Yes, 55.
Now there is, after this, there is no application pending. Your application is not pending. She has said that he is unable to join in the service. It is over. She has said, see there at page 55.
My lord, very fast, very good. Not see, very fast.
Your mother didn't challenge the rejection also.
Very fast, my lord. When I consider
You have said that several. You have said that several times. You have said that several times. The point is, your application was, your mother said you will not join, she will join. And her rejection is not challenged. Why you did not challenge her rejection? How this can be done? That after one rejection, another family member will apply. There is no provision.
No, one point. And after rejection, in the application, my lord, from 2010 to 2015, my lord, I have received my lord, pension. Family pension, I have received. Pension, I have received.
Everyone receives. What is new?
I am already running my pension. For the children, my mother was not applied for the commission. No, not challenged.
So then don't challenge it.
Age is over.
What are you submitting, sir? You are submitting against your own client. If he was all right with the family pension, let him remain all right.
And see, my lord, this he got the mother got the pension, and my mother given application for considering of her son.
There is no scope. There is no scope.
Age was over in 6 years.
There is no scope, sir.
For over in 6 years. And as far as my lord,
Why she did?
by the district state,
Challenge this.
that he is
This is your own doing. What can be done? Nothing.
my lord. And the certificate issued by the state that I am dependent on the mother. And if my mother is over in 6 years, if any time mother is expired, I am into my lord. Now the dependent on my mother, the certificate issued by the district magistrate lord. I am dependent on my mother. What can I do? After the night, study from mother, I can get the benefit. Now she can consider these aspects.
There is no scope. We understand, but there is, you never challenge. Your mother did not challenge her rejection. And after that also you waited for more than 1 year. Her claim was rejected in April 2015, and application you have made in August 2016. And you say because you were getting family pension, there was no need.
24.
Huh?
My application rejected on 24.
Correct. That is all right. That is all right.
24.
Where is that? Where is that rejection order?
Huh?
Where is the rejection order?
Page 88.
84 and 88.
88.
There is no power for review by the executive authority.
No, there is no scope for a second consideration. If at all they would have challenged the mother's rejection, then there was some scope. Now it can't be. What can be done?
Second was not the scope, and the scope, and the mother date was over the 60 years. and how can he challenge? For her faith.
In 2000,
For that reason,
in
mother requested number of times.
in 2015, she was above 60 years. Cannot be. 2015, her claim was rejected. She was not over 60 years. Take that.
Yeah.
All right. Sorry. Next.
Item number 7.
Yes.
That matter. But and remember that.
Yes.
Item number 8.
What is this? Yes. Oh, that matter which has come back.
Pending review application pending before this.
What have you done? What have you done?
My lord, we have already, my lord, complied. My lord, out of, my lord, 40 plots, my lord, 39 we already, my lord, recorded in the name of this company, and one application was missing. Then, my lord, I request my learned friend. He made an application, formal application. We will consider this one. My lord, kindly have a look. Out of 40, my lord.
Now you will not consider, you will do it.
No, my lord, only application, my lord, missing from this, my lord.
So you have, for fulfillment of that formality for missing application, you have taken the application. Now the direction is already there, so you have to do it in that case also. So how much time for complying?
My lord, 1 week.
So 39 have been complied with.
Yes. My lord, my lord.
So you take a copy, we'll adjourn it for next week. The learned, you
Item number 9. 10. Item number 10.
Your Lordship, I am for the petitioner. I am led by Mr. Sopose Chatterjee. He is in Delhi today, and I am praying for not today.
This was mentioned yesterday.
No, Your Lordship.
Not today.
Item number 11.
You're filing it. Has it been served? You're appearing. You are appearing. You want to file a reply? So you want to file a reply? Supplementary affidavit, you know. First week. First week. Fifth. Fifth January.
নামগুলো নিয়ে নাও আগে নাম নাও 11 নম্বরে এই যে দিয়েছি
Item 12.
The only short questions there. I mean, instruction taken as to whether the rather of the matter of petitioner was not money included in the is that correct? Rather of the petitioner has not been included in the basement form. And the lordship just guided instruction. His father means required to disclose the reason. According to the provisions, the father's name is not. But that is whether subsequently whether it was not surprised that I have to make application with my letter. While it has been stated that itself stated that father is selling. So he is not among the one. So there is no scope to
Lord, I'm for the state, my Lord. I'm being led by Mr. Sonal Sinha, madam. She is engaged in another court, my Lord.
ask him to come. Meantime, he is making this. So there is no requirement of disclosing his name in the proforma. In the proforma. And when you lordship can see this. This email only Baba sister in case of death. Sir, again we are asking you whether there is a requirement of disclosing the name in proforma. Don't show us the rule. Where is the proforma? Where is the proforma? Yes. And yes, which page? Page Yes. Now come to second page.
Second.
Yes.
Then measure particular submeasure. See, particulars of the oral dependence of the
So
dependence has been explained here. Has been explained here. The who is the dependent?
who is the dependent?
Dependence means difference the entire dependence upon the matter or the persons who died.
So therefore, your brother was not a
No,
dependent.
no, it is self-employed. And my lord, your lordship kindly see their affidavit. Affidavit, it has been also disclosed. And your lordship kindly see the attested copy of the affidavit. It has been par 2. On the same date, my lord, affidavit was filed. Next page, your lordship kindly see the affidavit.
What is the name of your brother?
Minal Kanti Panda.
Next page. What is next page?
Next page, my lord, affidavit.
Yes.
The affidavit, your lordship, perhaps your lordship not there.
No, affidavit is not required.
Yes, yes. Then, my lord, I affidavit. Sri Minal Kanti Panda is at about 31 years, 2, of son of Bangshidhar Panda by faith National Hindu, by provision service. By provision service. Yes, stated. And village sergeant, sir. And second, the Moshami Panda, his married wife, a married daughter, he has stated that Pio Vasantia has a do service from a funded that we are the permanent inhabitants of the self, I am the dependent too. I am the self-dependent and have been living in separate house since last 2 years. And I dependent number 3 declared that I am living with my husband in my matrimonial house, fully dependent upon the husband's of the income. So there is no need to disclose the income. And thereafter, your lordship kindly inquiry report. They have enclosed here and my income and inquiry report. Yes.
So if someone is living separately, they are not required to disclose.
No. It has been reflected in the inquiry report. Your lordship kindly see the inquiry.
Then what is the purpose of having column 6 at page 2?
My lord.
Then what is the purpose of having column 6 at page 2 of this form of the pro forma?
Pro forma.
What is
Yes.
column 6?
Column 6, my lord. Pro forma. Column 4, 5. A particular of all dependence of it. So can you see? See, it has been mentioned the whole dependence of it. The dependence has been mentioned that particular.
What is the purpose of having column 6? Please read.
Yes, living with separate or with family. Living with the family or living with the both the dependent. Sitarani, Panda dependent.
Sir, you please read 6.
6 are
Living?
living with family.
Living with family. You are deliberately omitting to read living separately. Does it say living with family?
Living with family, but that is Sitarani Panda say.
Read 6, heading of 6.
Yes,
No, you are not reading it. You are reading living with family. It does not say living with family. It says living separately or with family.
That is not living separately or with family.
Therefore, separately or family both have to be mentioned.
No,
And you have filled this form.
They understand. Only in my understanding. That it is not particular of dependent disease.
Sir, you have filled up everything in English. You have filled up everything in English. Everything. And don't say that you did not understand that separately also had to be.
I am saying this dependent has been explained.
What is, therefore we are asking you, what is the purpose of column 6?
Column 6 the dependent with there are 4 dependents.
Yes,
Suppose there are 4 or 5 dependents.
there are 6. Yes, then
One of them.
yes,
There are many separate. There are separate dependents.
yes.
So here my dependents are 2. Number rotate 2. Mother and my lord the son, one son. No other dependents are
A
there.
dependent will live separately.
Yes.
Dependent will.
Dependents live separately. It is reflected in this spot inquiry. That my lord Minal Kanti Panda is living separately. It has been, my lord, it has been, inquiry report is has been said. So my understanding is follow. That not dependents. If there are 4 or 5 dependents, one is permitted to make comments. And others may make no objections. They will no objection. So therefore,
That is not the issue. Who will make objection and who will make application? The issue is applicant has to approach the authority truthfully or by suppressing facts. That is the only issue.
So my understanding that
On your understanding, the system cannot work.
he has stated here.
The system has to work as per the procedure.
Particulars of the numbers of dependents. So therefore, he stated the dependents are 2.
Where is the rejection order? Come to the
Rejection order you will understand. That is rejection order they gave. Two times the rejection order.
Yes.
2 p.m. matter item number 9.
This second one, I have to. Right.
Not today. Come on Monday. Whether so unless that category is allowed, there is no question of any relaxation being.
No.
We'll see, we'll see, we'll see. Yes. No, some supplementary you were supposed to file.
All 7 except height. That I know.
The paragraph 2 country deliberately omitted.
Another 3 is 160 centimeters. So I don't know where I
Got it. We have understood what you are saying. The question of giving a statement regarding eligibility will arise only when the eligibility is prescribed for the category. Since that category is not open, it is not open to participate, therefore there is no qualification. But otherwise, no, there is one section where the female categories are allowed. So in that, the minimum height which has been prescribed, you are having. You are also unreserved.
I'm but I belong to those persons of plates. Well, I fall under the plate. Anybody? I am more than 160 because of height. All the parameters are right. Otherwise, we had that been this for an involved law, or putting entire thing not before, but not before. But this situation of your logic, but I'm going to pick it back. I do not think we
Yes, place it. Yes, we know. ROJER, not GER. Roger is spelled in this.
Huge amount of money. Beyond 10. Imposed or the risk or would not apply. Such details are intended to find a condition under Article. The basic structure of the Constitution and be at all.
Why? No, what is the law that emerges from the three judgments? Complete exclusion. Correct. So, as far as we remember, before you place the judgments, we'll read it. The judgments are, in so far as the law, what it says substantially is that there cannot be a complete exclusion. Having said so, does it say that having regard to the separate cadre of services, it is for the employer to determine total 10 were allowed. Correct. The court did not say, the Union of India said that we are allowing. Yes.
If they can fulfill all of the parameters as one of structural commission officer, their permanent commissioning cannot be denied on the basis of the agreement. In any sort of things were more difficult. One of the officers, as because those ships are made by the Russian, those are old Russian ships. But there's no permission. These are one of the things taken in our signing of that. But there are also lordship that this or this will be practically problem of not having a restroom for a washroom for a woman can be. This cannot be any harm. But it has to be given on basis of
So here, what is their case? They are not saying anything like this.
sorry, what they are saying with regard to some inspector of police, unarmed guards, or I can participate in the post of sub-inspectors of police unarmed. But with regard to armed branch is concerned, female candidates have been completely excluded
As well as sergeant. Okay.
I will say what I am not saying certain about advertisement is understanding, but I'm not telling you. Elements here are different than the some inspector inspectors or armed guards. What I'm saying is for the recruitment post of non-inspector and sub-inspectors armed unarmed guards. Not it's a different issue. Or I'm entitled to be unarmed guards. What or content in the complete our purpose. But these rules over 1960 were guidelines. We are seeing the 1960. But much water is from getting. We are now exactly. Now our question of pre-option goes better than just all the women were not allowed to do. These are possibilities today. But now things have changed. Now they are at equal footing. Now only this is their genders. This segregation of one set of persons or get a public employment or public service is not absolutely I would say violent party which gives people a cause. But now I mean outside because of one rule that exists from 1963 or fact that we should give up. This cannot be pushed by taking the house from the exam. But
The 68 rule provided for inclusion of females only in a particular no, where the cadre strength has been defined that how many females and male can be. So it's a 21 rule. No, that is not before us. The rule under consideration was framed in 21. It's not some old archaic rule.
Which doesn't have any basis. I don't know this how we get individual class. Whereas I can participate in around class. Why I participate in around class? But this is nothing. Only is I will be having guns. One is law and order situation in battalions, one is the law and order situation in police stations. Only difference is this. For both the cases I mean, the condition has a right. We have to utilize guns. And one of the nothing is whatever is there.
So according to you, whether armed or unarmed, you have to operate an arms either way. So what is the armed force? So they are available for reinforcement or such things. So this nomenclature, distinction in nomenclature has nothing to do with the fact whether they are having arms or not. It is only two types of forces. So on what ground you are saying it is not permissible? No, similar situation will be drawing a similarity on facts. So which fact here in this case makes the classification unsustainable?
With regard, what is the reason, cogent reason? I completely outstepped in the during the
We don't remember.
From black and white, we have why this simplification? What is the within reason? For which one of this simplification are not given the complete outside? Because that is not there in the opposition. So, what are the my lordship? The third thing is an examination, which is going to the extent, I'm not saying I got because I'm not challenged it. With regard to the inspector of my at least for some action to be given. Also, they are continuing issues the official has said as well. Administrative or well not doing anything, so after distribution passing out. Now, after that order, so they started this process. Second round, I started at India. Now, the third round is going to start. Now, if third round and there are exclusively the other one started as only
So after this written examination, there will be one more stage.
Now the written
And prior to this written, what has happened?
If somebody qualifies in these two, or they get to the third or that is called 85 marks. If they qualify that 25 marks for, then they are the selection takes place. So, these two steps for the examination, which is going to start out getting off. So, I want to have to be I'm not saying that certain what I will not say at the right of it. But the some inspector of police, HON'BLE, yes, hearing of the council. Also, I think if I succeed, if I succeed, but then somebody that would have been created as we go. But then the people will say that these many the person who inspector, you are making the particular applications for that go there. So answer was fine. Then by the time this is over, I will be fine. This is the situation on their protection and on if they have that because of OBC category, OBC examination, the OBC matters, examination has not been conducted. Now that hurdle is being opened out, and the conducting it for going to be there. And your option is this point is already in beginning with this matter with finds you. That is it. This is the combat of I usually they will proceed to take forward and I will be outside. I am going to be completely outside. From this selection process, and might just come up at the outside of the entire thing which I understand. So this is my answer.
But the other two stages which have crossed, there was no interim order.
Section 5, subsection 6. Clearly specified as single by that time, about the implementation was taking place. But not over there. Well, that
Where is the advertisement?
categories except gold.
Fine. In your category, it is 155. No, that we have understood what you were saying. But you have said that you fulfill the 160. Where is the rule? Let us see the. Oh, it's 23, not 21.
Well, this is the criteria for male candidates. For male candidates, say 1%. 70 years, 80 years, maximum extension of 5 years. Age is 56. Your the broadcast approaching the governance and human rights is also 76 and now the subject of boundaries or 73. Now we have about 2.5. That is for female candidates. We have been only stuck with one. So that is substrate discoveries anomalous with the evaluation. Now there is C. That is transgenders. But we have also substrate anomalous with the evaluation. We have the idea of all these circuits. Now five eliminated criteria. Each of the candidate must not be less than 20 years and not more than 6 years as a one first category of the advancement. Provided that according to the flexible by 5 years. By 3 years in case of other backup and by 2 years in case of counting persons. So I already I was 8 the accurate partition. Now what female candidates are apply to the post of some status or yes, and shop. So I think complete out of here. But counting the cost for any capital can get person legal determinant and qualified physical efficient and economic operation. So the key part is next to but there are information, why did the mark? Only candidates qualified both the final combined competitive test. Now since it is over, the final combined competitive test, combination type of question. Final combined competitive the syllabus, the final combined
You have not dealt with the merits of the matter in your opposition. In your opposition, you have not dealt with the merits of the matter.
Because matter was pending at that point of time before the trial.
No, no. You filed an opposition in March 2025.
Yes.
Why have you not dealt with the matter on merits?
No, because at that point of time, we were not aware that whether it would be heard by this court or by the tribunal.
So there are two oppositions to be filed, or in one
no.
opposition you have to file everything.
I had the impression that matter is yet to be decided by the tribunal.
If you choose not to address on merit, then it is your choice.
No,
We don't know of such a situation where one affidavit will be filed on maintainability and another affidavit will be filed on merit.
No. At that
If at all you are to oppose on merit, you are required to file everything.
At that point of time, matter was pending before the tribunal.
Even today it is pending before the. So
still pending.
So
then, we expect that when the matter will go to the.
You are. Is that a stand correct? Is that are you supposed to take such a stand?
Because
that is what we are asking you. The affidavit has been filed by a high official. He has chosen not to say anything on merits. Then
because
proceed.
Only interim order should be granted or not. That's all the question.
How do you know? Where is the CAN application?
No, can you see the prayer in the petition?
All right. So therefore, you may make this an issue. We are asking you a very simple question. You have chosen not to say anything on merit. You may presume that we will not hear the matter. You may presume. Nobody is stopping you.
Kindly decide whether he has got locus standi to maintain the.
All right. So is it to be decided separately or it is to be decided as a whole? Is there any law which says we must first decide the maintainability, then only?
No. Normally, maintainability point is decided first, then the merits is decided by the court.
We don't know. If this is the advice, then we don't.
And kindly consider.
So till now, there is no stand of the state on merits of the matter. No stand. Nothing.
No. Kindly consider. Assuming for a moment that reservation or not making provisions for the ladies.
They are not claiming reservation.
No. Making provision for ladies in respect of which post? 3 posts. First, sergeant.
They are only concerned with armed branch inspectors. They are not concerned.
Second is unarmed branch.
Yes.
Unarmed branch.
No, armed branch.
Unarmed branch. Unarmed branch, what is the height? There is not a single sentence or document before your lordship that.
So therefore, again we are asking you. We will proceed on the basis of the opposition that you have filed. Your only objection is they have not stated the height, and your other objection is that this matter should not be entertained by the court.
No, I'm not saying that.
Then let us proceed.
I'm not saying that entirely. Because now this tribunal is not functioning. I know that. The High Court is not.
So as long as it is functioning, then you are not required to file opposition.
No, but my lord can hear out.
What kind of stand you are taking?
No, since the tribunal is not functioning from September, my lord can hear out the application, so I cannot oppose that prayer. Then, kindly consider whether on the basis of the pleadings made in the original application, whether he can maintain the writ petition or the original application before this honorable court.
All right. So that is your only response.
Yes.
Nothing else. You don't want to say.
Second, Second is, my lord, what are the rules? That rule said that there are 4 stages of exemption. First, preliminary exemption. Second is PMT. Third is written test. Fourth is interview. First stage is over. Second stage is over. If first stage, second stage is over, those who have qualified, because cut-off marks is there, some right has been accrued to them. Now they will appear in the final exemption. There is no interim order. Because of the interim order passed by the Supreme Court, we proceeded with the selection process.
So we'll proceed as it is. So you don't have anything to say, yes? Yes, we should proceed.
I think that we should file an affidavit. So for the merit is concerned, certainly we'll file an affidavit.
Is for you to decide if whether you want to contest on the basis of
Any chance to file an affidavit or not? But no interim order should be granted because
within a week. You file it within a week.
kindly make it kindly give it 2 weeks time, my lord, because
Then we will not have time.
No.
Then we will not have time.
because has to be approved by the Commissioner of Police.
Then
10 days time, 10 days time will be given. No, no, but kindly consider, there are 4 stages, 2 stages is over.
you have already said that.
Yeah.
You have already said that.
Well, that is the written examination.
May I make one suggestion? Subject to my document. Kindly record my concession. Because this selection process is 2 stages over. Now the next step, if whatever my lord refer the matter to the government for next selection process, considering the case, considering the condoning the age.
We have not understood what you said.
This selection process is on 50% of completed. Now 50%, very difficult to unsettle the matter. Then only remedy, subject to approval by my lord, but kindly consider, do not make it as a concession. My lord referred it to the government to consider their case, whether the government can, because of the Bobita Puni and other judgments, whether any reservation can be made accommodation can be made to the ladies. Because of the poor. No, Bobita Puni is different.
Just he is making a submission. What we can do is we can keep it in the next meeting. If he says that they are going to take steps. You take such instructions within this week. We are not asking you to file an affidavit. You take such instructions within this week. And we will keep it on Monday or Tuesday and then we'll proceed. Yes.
What are regarding?
Yes.
What are regarding, Madam?
Huh?
Regarding
Whether the government is willing to reconsider? You take instruction.
for the next selection process.
No.
Madam, this selection process are very difficult. This selection process, but the government will not. I don't. Without the instruction, I said, the government said no. This selection process we cannot touch it because 2 stages is over. Next selection process certainly we consider.
So in the meantime, whatever you want to, if you want to prepare on the merits of the matter, you may prepare. We will keep it on Monday. Because you have not filed any opposition.
No, we have filed it
on the merits.
Merits.
Now, whatever is being submitted is basically submission of law. Not much fact is involved. Whether there is any factual justification for exclusion in that cadre or not, that is the only thing you have to say. So what is the big deal? You can file an affidavit.
Madam, we'll file within 10 days. There is no difference.
10 days, it will be too late.
10 days, reply within 2 days, the 14 days.
And when it will be heard, we only have 2 weeks of court. Cannot be done.
Madam,
We only have 2 weeks of court. How it can be done? Cannot be done.
no, today we are. Just give me 1 second.
It cannot be done, sir. We are telling you.
By opposition by 19th, by 19th, reply by 22nd, can be taken about 20.
And on the last day, we should hear the matter and decide it.
Very difficult, very difficult, very difficult.
You are making a unique submission. We don't know.
Very difficult.
Cannot be done. Therefore, we are saying cannot be done.
Very difficult.
Not only difficult, your hearing will not conclude. Once the hearing starts, it will take some time.
It will take some time. Because it will decide the question of appointment of lady officers whole over West Bengal, not only Calcutta police, Bengal police also. Yeah, far-reaching effect. And this type of officers, because there are 2 types of cadre, investigating cadre, non-investigating cadre. Armed sub-inspector or armed sub-inspector, they are non-investigator. Only they are controlling the mob or agitation or a riot. That's why the height is mentioned at 6 foot 8 inches.
No, but what is the right which has accrued if the marks in the first 2 stages are not to be added in the next process? Then what is the big deal?
Can you see the advertisement? Can you see page 46? Plan of exemption, preliminary exemption. The preliminary exemption will be held on subject and general basis, so logical and analytical reasoning, arithmetics, multiple questions, objective types will for marks of 200 marks, 100 marks for general studies and having 50 marks, and in logical analysis, reasoning 35 marks. The preliminary exams will be securing.
You prepare yourself on,
for physical test.
at least you prepare yourself on the interim relief. We will keep it on Monday.
Monday or
The learned. Yes. Advocate. The top in the morning we'll take that.
People.
item number 103.
Categorized sets of employees. One is composed cadres, rather. The other is non-active. And Coal India doesn't have any uniform one pay structure.
stay and other facilities, parks, everything for these two categories are 10 to 7. For included the pay is paid by the government of India. The gap of every 10 years. Which government of pay commission for all the central fees. And they give a number of hierarchies. And according to the respective capacities, the PSs allocates. Whereas in the non-inclusions, the pay is fixed. The regular interval of every 5th year on the basis of an agreement, national code wage agreement, enforcement under the industry. What happened in this case? The non-agreement at the top rate of their supervisory cadre A and A1. They had reached the end of their pay. Because switch from non-executive to executive cadre is not possible. It requires an examination, interview, and then only one can put. Now some people are in the was setting the supervisory grade AA1 full India for a number of times. I too experienced old examinations. I do not know what happened. The employees are not really willing to face it. But some issues were other or very few people are here. The examiners were effective. But they were hesitating or switch to executive. But Coal India did, as an exceptional case, as one time did, they upgraded all people stagnating for 15 years in supervisory grade A1 A1 to executive cadre E1. That is the lowest hierarchy of it. As I told you, the pays are decided for executives at the gap of every 10 years, whereas for the non-executive is 40 years. Now, when the non-executive pay scale, NCWA pay scale, National Coal Wage Agreement pay scale, were about to end some hardly 6 months or 1 year later. This group got this group upgrade. And it was not a blanket benefit. It was a condition. Conditions were imposed, options were invited for them. This is the thing if you want to come up now. But if you want to go up with the hierarchy, go to E2 and above, you have to face the representative. This is one time. Now, a lot of people accept. Therefore, what happened? The non-executive pay scale was revised at the end of 5th year. Executives were standing still. In some cases, the basic pay of the non-executives became higher than that of the basic pay of the E1 or equivalent. This is the sum and substance of dispute. Therefore, it started. Facing this situation, Coal India circulated an option. You will really understand it. To understand your heart is burning, you are at liberty to go back without any prejudice to non-executive cadre. Some 200 among them accepted this and they went back. Now the respondents, the private respondents there, they are insisting on remaining in the executive cadre and getting the benefits of both the executive cadre and that of tenants fixed non. All India's stand has always been that these are not two comparable things. There is no equivalence. You are a distinct class, executives are distinct class. You have, by exercising your option, chosen to switch over to executive. Now we're going to have best of both the worlds. We have to choose one. Either remain here with this pay scale, because the limitation is the pay scale given to the executives are dictated by government opinion and applicable all central PSCs across India. Whole India is not divided between them. You can't mistake, change it. No dividing. If this is done, then it can be almost fine. Lots of time up there, you know. 8,590. All of the three. Oscar is quite good. The everything part custom 590. Hello, good. Appealing for the petitioners on instruction waivers. Payment of costs by respondent who is restricted will be directed paid to petitioner by the order of the judge. Therefore, there is no impediment to the executive opposition being filed and being taken on record. Every opposition filing good is.
We are going through it. We are going through it.
of this.
Yes.
This is against the prayer of the petitioners. Volume 1, page 7.
Please come in. You are recording from your phone.
The prayer is correctly formed. Small b. A read off and in the nature of mandamus. Directing the respondents. But page 74, volume 1.
No, why this direction of the single judge cannot be implemented?
Because circular relied on by the honorable director or the brief. Is a guide by the government of India, Director of Public Supplies. On the matter that while negotiating for the wage revision of the non-executive, you text here that their pay do not exceed that of the executives. That is the only thing. Not the inverse. What they were asking for the reversal. Now they are asking for revision of pay of the executives, remaining in executive branch. What is beyond action of beyond our power? Someone upset about it.
Where is this P20?
One. Volume 6. Page 476. Volume. Second volume. I'm trying directly to convey the decision of the government of India that the next round of wage negotiation, which falls due on a general basis from 1/1/17, the workers of the central public sector enterprises may be undertaken by the management of the enterprises to the trade unions associations. Wage negotiations and finalization will be subject to the following conditions. Management of the CPSC would be free to negotiate wage revision for workers where the periodicity of wage settlement of 5 years or 10 years has expired generally on 31/12/16. In some companies, it might be for 10 years. Keeping in view the affordability and financial sustainability of such wage revision for the CPSC concerned. No budgetary support for any wage increase shall be provided by the government. The entire financial implication will be borne by the respective CPSCs from their internal resources. In those CPSCs for which the government has approved the restructuring revival plan, wage revision will be done as per the provisions of the approved restructuring revival plan. The next one is important. The management of the concerned CPSCs have to ensure that negotiated scales of pay do not exceed the existing scales of pay, executives, officers, and non-unionized supervisors of respective CPSCs. The management of the CPSCs where the 5-year periodicity is followed have to ensure that negotiated scales of pay of 2 successive wage negotiations do not exceed the existing scales of pay of executives, officers, and non-unionized supervisors of respective CPSCs for which 10 years periodicity is being followed. This small Roman 4 and 5 and 6 things this pyramid which have been quoted by the government.
Yes, read 6. What does 6 say?
6 says, my lord, to avoid conflict of pay scales of executives, non-unionary supervisors with that of their workmen, CPSCs may consider adoption of graded DA neutralization and or graded fitment during the welding.
So what prevents you from doing this?
This entire circular is directed for governing the relationship between non-executives and executives.
That is precisely the issue.
This does not vest any benefit or right on the executives.
What
They have
does-
become executives on choice.
Please read 6 again.
To avoid conflict of pay scales of executive stroke non-unionary supervisors
Yes.
with that of their workmen, CPSCs may consider adoption of graded tier neutralization and or graded treatment during the oil negotiations.
So how this will not apply to executive? It says executive stroke non-executive.
This is again oil negotiation with the non-executives.
No, it is not. It says executive stroke non-executive. How can it be limited to a non-executive? Please read. That's why we said read twice.
Kindly read. To avoid conflict of pay scales of executives,
Stroke non-executive, both, not just one. A graded DA for neutralizing the issue.
CPSC may consider already DA neutral. The DA neutral has to be done for the non-executives.
That is the whole point. That's
But
why
they are-
that is why the Honorable Single Judge has directed. That is your submission, Bill.
There is an executive cadre.
Those who are in executive cadre, according, if we have understood by now what you are submitting, they feel deprived because they are no more workmen. They don't get the benefits there. Here also, although they are said to be executive, but they are getting less than the workmen. Now, such a situation you want to continue in the organization.
Before incident.
Did you file a
This non-unionary supervisors, they are also no.
Please come prepared. This is not the way. Every query, if you will start consultation here in the courtroom, then it is impossible.
I appreciate. I'm sorry.
And advocate. The other side of the holiday, any date, which date? We cannot see. There's hardly 2 weeks. Please see.
And Mr. Mitra also has prayed for that. If possible.
No, given a
immediate
date
after the
so
vacation.
that we can finally consider it and finish it. It is unnecessarily, we don't want to keep it. Can have it on. This is intra-court appeal. Any day, any Wednesday. Intra-court on Wednesday. We have fixed a day for intra-court appeal. Yes. So it can be 7, 14, 21.
So 14 would be convenient.
Yes, sir. 14. As jointly prayed, the matter is to be listed on 14th. At 2 p.m. At 2.
Number 146.
We find no reason to interfere with the order passed by.
Item 147.
Yes, we have allowed the registration, setting aside the offer.
Number 13.
Not today. We come on Monday.
Item 14.
Mr. Mukherjee. The time of filing.
Please, পরে দেখতে। Please, পরে। হ্যাঁ।
Item 15.
15. The paper was corrected. Now your lordship kindly and tell you the background of the case. Passed MBBS in 1997. In 2004, he joined West Bengal Health Service. Now in 2013, she preferred to join West Bengal Public Health Administrative Service. Now in 2020, she passed master's degree, that is specialization on oncology. Now she applied for shifting to West Bengal Health Service area. That was refused. On the ground, they showed one notification that option was once opted out, chosen, chosen again.
That exercise is irreversible,
That is
according to their stand.
yes. Now I will subsequently come to page 26.
So she joined in 2004. She migrated to Public Health Administration Service 2013 by exercising an option. Then she did PG in oncology in 22. Now by virtue of acquisition of this qualification, she wants to go back in the health service.
Because my lord, in public administrative service, there is hardly any scope to treat patients. That is why she opted.
Let's see.
Now your lordship can come to page 26. That is the reference there. Now, my lord, rule 4. I am reading, my lord. Notwithstanding anything contrary contained in the foregoing provisions, any person appointed in the tiers of basic public health administrative officer or administrative officer would be in the cadre of West Bengal Public Health administrative subject to provisions of section 8A of the West Bengal State Health Act 1990, and in terms of the these rules shall be eligible for opting out to a post in the West Bengal Health Service. The option so exercised shall not automatically entitle him to a post in the West Bengal Health Service, and actual reversion of such pension to the West Bengal Health Service shall be made in phased manner. Now, they are taking note of this. The option under Schedule 1, once exercised, shall be final and shall in no circumstances be revoked at any subsequent date. So, to them, my lord, this subsection 2 goes against me. Now, my lord, may submit my first submission is on this issue is this. My lord, this section 4 of this notification clearly indicates that those who are in administrative service and want to exercise next option, that will be fine. But it does not recommend or include the previous option. It never says that. Now, my lord, the third paragraph of section 2, subsection 2, provided that upon such a reversion to the West Bengal Health Service, the concerned person shall have to forego the additional incremental benefits attributed to him consequent to his absorption in the West Bengal Health Administrative Service. However, can you take note that I have not received any advantage from that. I have made application for getting advantage of that position in public health service, but the same is yet to be discussed. So my first submission is applicability of this section.
So this exercise of option to go from the PHA service is not linked to the earlier exercise of option.
That is why
This is your case.
number 1. Number 2, even if it is considered or taken on the face value that it is applicable in my case, then, my lord, there are certain discriminations in the opposition also. They fail to deal with my point that as to why the discrimination has been made. Now, who are those persons? Your lordship can come to page 33.
Before that ballot, 32. Before ballot, 32. My lord, will get serial number 5. Hanuman Mondal. I will cite ballot 4 examples. This is the number 1. Dr. Hanuman Mondal, medical officer, SNCU, COM such and such. Now, my lord, in the top, my lord, it is written. This is the notification for the year 2014, December 2014, at the top. My lord. Now, Hanuman Mondal in 2014, my lord, he was migrated to, allowed to migrate to BMOH Hugulia. Now, my lord, BMOH is the post which is within administrative service. But acting BMOH, my lord, that is health service. So, this doctor was allowed to opt out to become the BMOH of a certain health center. Now, your lordship can
No, but she is in the WPHS administrative service. She has migrated to administrative service.
So,
But you are seeking the reverse.
no, my point is this: he was allowed to exercise such option in 2014. That was the first thing.
All right.
Now, your lordship can come to page 33, next page. My lord, second paragraph. This is the notification of 2020 at the top right, 2020. Again, the governor has been pleased to accept the technical registration tendered by Dr. Hanuman Mondal, such and such, in the discipline of
No, in the Kadara.
No, I will just keep it. In the cadre of West Bengal Public Health and Administrative Services posted at Sultanpur Block Primary Health, Birbhum, to allow him to join the post of T. Demonstrator. So, my lord, in health service.
So he has been allowed to go in medical education.
Now, my lord, in health service, there are 3 categories: one health service, one administrative service, and the education service. So, those who are in education services, my lord, they impart education to the students. And administrative service deals with the administrative affairs, whereas my lord, the health service deal with the patients directly. So, this is the total my lord treatments. Now, my lord, this doctor.
You are not claiming to go to the medical education service.
So, because my age is over, I am now 52, so to go to the education service is not possible. Now, my lord, Dr. Hanuman Mondal was allowed twice. Next, you will also come to page 32 again. Serial number 14. That is Kalipodo Soren. BMOH acting such and such Purulia. Again, that is the notification of 2013. 2014. Now, you will also come to M. Before Kalipodo Soren, kindly come to serial number 16 of page 32. Dr. C.C. Bisa. Page 16, Dr. C.C. Bisa.
Yes.
He owns Mongolkot BPHC Barbar. He was then opted out to BMOH Mongolkot such and such. Now, your lordship can come to page 36A, third item, my lord. The governor has been pleased to allow Dr. C.C. Bisa, Ketukra BPHC 4.1, under West Bengal Public Health Service cadre to opt out from WBPA, WB first cadre.
So he has gone to the health service.
This is second. And now,
You also migrated in 13. And these persons, they migrated in 14.
And another person, that is at page 39A. page 39A, my lord, Dr. Ryan. My lord, it was transferred by notification dated 2022.
When he came in, when did he come in the administrative service?
My lord, that is the 2013 notification. That was not annexed. That is why when the paper book was not was prepared, my lord, I did not annex that. But here is the document. My
Anyway, two instances you have shown.
yes,
That is
here he also appeared 21.
in this same list.
Same.
Dr. Somen Datta.
That is Rajiv Ghosh. Page 39, your lordship is the latter one, your lordship is finding 39.
Yes.
Rajiv Ghosh. And he was initially opted out in 2013. So there are three instances.
The two is enough. Two is enough. Yes.
So this is my case, my lord. Your lordship can consider as to why the discrimination will be there. Number one, and second submission is this: the notification they are banking upon, that is not applicable in my case. These are the two-fold submission.
And what has the tribunal held?
It held that that is act.
Because if the rule sub rule 4 is given the meaning that you are saying, then if you go back, you will have to forego whatever benefits you have earned in the administrative service. That you will have to forego.
I'm ready, and because I have not received any.
We don't know if you have not received, but the rule says that we shall have to forego the additional increment benefits accredited to him, and he will be treated as continuing in the health service.
And when the tribunal held the same view of the government.
Where is the tribunal's?
Page 130.
Page 130, that is second volume.
One 138.
Yes, one of the relevant portion is 139. Second paragraph. Quoting this subpara 2, subclause 2 of section 4, I think has not been entertained.
What is this memo of 11/3/24?
Page 48. Page 48.
Page 48.
48 is the first. Hormone. That is the rejection order by the department. My name is appearing under serial number 6.
So you did not challenge this.
The tribunal has held that setting aside of that order has not been prepared, but I read for our
Let us see where is that.
page 16 and 17. 17 is my prayer one. That order was not taken. The word my lord setting aside was not in, but your lordship kindly condone that mistake, my lord, to direct the concerned respondent to allow the applicant to join health service from public. Unless that is set aside, my lord, kindly.
Yes.
What is the prayer made in that?
We have seen.
Respondents to allow the applicant to join in the West Bengal Health Service, West Bengal Public Administration Service, not to transfer any rural hospital, and further not to transfer any hospital lower than the subdivision hospital where the applicant is. And can you see page 48? His prayer was rejected. His rejection order was not challenged. And can the tribunal pass an order not to be transferred in a rural areas?
No, that is not the only prayer. The other prayer is to join the health service.
Health service. But health service prayer has been turned down.
Yes.
And this memo has not been, order of the government has not been challenged for setting aside the order.
You filed a reply before the tribunal.
No, we have filed. But that one is. We have filed opposition here. And she is opted from health service to public health administration service in 2013.
So what is your submission regarding this lack of prayer? You have not prayed for the relief, then what is to be done?
Your lordship kindly appreciate that unless the order itself is set aside, next prayer cannot be made. Yes, that is a defect. I admit, my lord, but when I will be considered as eligible to be transferred from one post to another post, especially when the rejection of order is there. That is an extremely technical point, my lord. But considering the overall aspect, my lord, kindly pardon both the petitioner.
It's not a question of pardoning. It is a question of the right of the respondent to deal with your case. It is a question of compliance with principles of natural justice. Unless you raise an issue, how they can meet it?
They can here and now, because unless that is the order of transfer is given, my lord, that has to be given by overlooking the previous.
Where is your initial exercise of option?
In 2030. It's 2030.
Is that on record?
My lord, that is not on record. But we have said so in paragraph H, page 3, in admitted 2013, March 2013.
So apart from the fact that they will be foregoing all the benefits, then what is your problem?
Because Monad, he wants that he should not be transferred in a rural area. That is not possible. Because he wants that I should be giving West Bengal Health Service.
Anywhere,
But West Bengal Health Service is a transfer service. And admission service is limited only where there is an administrative post is available. Just like sub-divisional hospital. This is called super. Only in the part in a district A is called CMOE, administrative post. And in a medical colleges, it's called vice president of MSVP. MSVP.
No, if he is willing to forgo, if she is willing to forgo what,
then it will be difficult to be because 2013 she exercised the option. Separate gradation list is prepared.
then how you allowed it for others?
No matter because of only so far as teaching post is concerned, one of those who are in medical education service for the benefit of the student.
No, you have given for medical health service.
No.
Yes.
Yes.
Yes. You have given in health service also. Shishir Biswas, 36A.
Governor, please to Dr. Shishir Bishwas, BMOH, Ketogram, BPH, Purvo Bardhaman, West Bengal Healthcare Administration Service, color to opt for Secretary West Bengal Health Service as per existing rules with effect from the which is
Yes, health service. This is the only rule which he is referring to.
Yes.
Rule are annexed.
Huh?
No. Rule have annexed at page 7 of my
Page 26.
Page 7 of your reply.
yes. Page 7. Paper book.
162.
152 or 162?
No, 162.
No, 162.
So that is your reply.
Sir, you'll also get it from page 26 also.
146.
August 2004. This rule may be called West Bengal Public Health Administration Service Rules, Option Rules 2002. This rule is applicable only to this person, not for other persons. Can you see the language? These rules may be called West Bengal Public Health Administration Service Rules 2000.
From where you are reading?
Page 152 of the second paragraph.
Just a minute.
One 152 too. It does not apply to the West Bengal Health Service or does not apply to the West Bengal Education Service.
What about the others? There were 11 persons. What happened? The others have also. No, they were all under public administration. Correct. So now he is member of that, not now he is member of that service only. This Shishir Biswas is also under the West Bengal Public Health Cum Administrative Service. Same.
West Bengal Public Health Cadre to opt West Bengal Health Service Cadre, West Bengal Cadre as per existing
To opt out and go back to the health service. See, what it appears that this rejection order is relying on the main provision without considering the proviso. The proviso says it can be allowed subject to certain conditions. That has not been considered. You see page 48. The option once exercised shall be final in no circumstances. But the proviso has not been considered. Whether in all circumstances she will have a right to go, that is a different thing. But the proviso has to be considered. And if she is willing to abide by the proviso, forego all of her increments and any benefits that she has.
Proviso cannot override the main provision. Proviso cannot override the main provision.
Obviously, nobody is saying that, but the proviso has to be
Provided
considered.
upon such reversion.
It is your proviso. It is your proviso.
Provided that upon such reversion to the West Bengal Health Services, the concerned person have to forego the additional incremental benefits accredited to him consequent to his absorption in the West Bengal Public Administration Service as per provision of the West Bengal Administration Service Rules 2004, and thereupon pay should be refunded such manner that may have been entitled to at so long as
All along, he will be considered as being in a health service all along. So he will not get any benefit of this public administration service.
No, but whatever. The only difficulty is, Ballard, seniority is maintained by the department.
But those is reasons you have not assigned. Therefore, we are saying the moment you consider it under the proviso, you may come up with a case that it is not possible for such and such reason. It is not that whenever one is willing to forego by he or she has a right to go back. That's not the intention of this notification. But it says it, the proviso carves out the exception that it can be done in this way. Does not mean it has to be done. But you have not considered from that aspect.
The proviso has not been considered.
Not
Only
considered.
Main provision has been considered.
So that is required to
Whether
be considered.
main provision or proviso can override the.
That's not the point. There is no such issue arising. The issue is that his claim has to be considered under 4(2) read with the proviso. By just considering one line, you cannot do it.
Because rule 4(2) has to be read as a whole.
With the proviso. Proviso cannot be excluded.
Provider cannot be excluded.
Proviso
Provided why proviso is there? For exception cases.
Correct. So therefore, whether he will, once you look into it, then you can say that he will not fall within the proviso also. But you have not examined it from the proviso. So how long this order has been passed in March 24? You will not, we don't know whether you can claim a right to go back, but they are required to consider you under the entire rule with the proviso. That we can direct.
Because I do not know how many persons will be affected because of seniority.
But you have not looked into it.
Yes.
Maybe nobody is going to be affected.
And he shall have to refund monetary.
Whatever that, as per law, the consideration must be there.
And she must give an undertaking that I will refund according
She will have to. The moment the proviso applies, then it will apply to her. It is in the proviso.
Yes.
So you consider it let her make application afresh. You make a fresh application.
Then, my lord, that should be considered. Yes, certainly.
Yes. The
Item number 16.
Application when the matter was taken up. Like this. Handing over
That is on which issue?
that this is regarding mother.
Sit out, sit out.
Mother was
You got the judgment.
yes.
No, no, no.
Give me 1 second. This is 6 though. I had a green copy.
Whether that judgment has been complied with, or what is the status? Mr. Mukherjee had given you the detail on the law.
6.
You don't have it.
Yes, I had.
Tomorrow is 10th. So tomorrow we'll tell them.
Judgment dated 26th August 2025.
Thank you.
Exactly.
No, that's why we wanted you to see whether the facts are at variance or the facts are.
Facts are almost the same.
So there is some nuance, insignificant.
I will add on to that because your lordship has the occasion to go through the papers to repeat it. One thing is that after my case was presented to the respondent, it is in the academic competition. The respondent is admitted that I am entitled to get the Calcutta. I mean, I was interviewed, a physical test was done, and I was complete to get the. In spite of that, in the result order,
No, they must have said it cannot be transferred. What have they said?
can we have a look to the order? One below.
No, in this case, perhaps it was rejected by saying it is not transferable. This is the case. Today we were looking for this case in some matter earlier in the day. No, today in the morning we were looking for this for some matter which was taken.
This one.
Yes. I asked the learned advocate that he should examine the judgment we have passed. Oh, yes, it was your case. So you have it. So this is the judgment. You take the detail. It will help you. Therefore, we are saying. Yes. Prior to 2008. That you will argue, but go through the judgment. 26 EMP 26 says all pending applications will be covered. Correct. After 2000. Yes. 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 It says those matters which are pending from 2008. We'll see. We'll see. You may, it will be only benefit you if you go through the judgment. Want us to write this big order today, right now? Today you have come with the judgment for the first time, and don't expect us to remember everything from the last day. We are only humans.
Absolutely. Absolutely. But only the Mac will come next week.
It will come on Monday on its own.
Monday. It will not take more than 5 minutes. Why can't keep it as CA?
We don't want to do that. That's why we are saying that is the easy thing to do. We don't want. We'll dictate. We'll pass the order here in the court itself. Now, since we have this, just give us the bare facts.
But it's a probably minus second.
Just a minute. Now just show us 22/6/2006.
Yes. 22/6. Yes. Page 14.
This is so old, from 2002, 2006.
92. That they have taken the decision that they kept it pending, continuous.
On 9/9/24.
And if your lordship takes up the affidavit in opposition filed by the state.
Where is this 22/6/2006?
Page 40 of the because my mother was found ineligible because of the health.
Why you have been sitting for so long?
No, I was listening. But
From 2000.
I approached the department constantly by making letters, and department there was an interdepartmental correspondence. All the records are before your lordship. The interdepartmental correspondence always speaks for myself. Give him appointment. Even the inquiry, can you have a look to the.
So this is the first OA filed by you in 24.
Even the inquiry report of kindly turns to the affidavit of opposition. The inquiry report supports my case. 3 months inquiry.
Whoever has submitted a pro forma, the 3-member committee is only to inquire into the financial status.
No, not only that, but everything they have mentioned. But I was interviewed by them.
Correct.
I was found fit.
Correct.
In spite of that,
No, after so many decades, you must see, you please go through the decision of recent decision.
that.
Which one?
The Nagaratna judgment.
Yes.
It's not wrong. They were both,
Yes. Yes.
Yes.
And then I will tell you one more decision of the Supreme Court. If the delay occurred because of the national department state, what is the
No, those are general principles. This says about compassionate appointment. The underlying object of the scheme, and whether at such a belated stage the court should pass an order, that has been considered.
Who is that for? Is it me?
Therefore, we asked you from 2006, did you ever approach any forum, or you were just communicating with the authorities?
I was communicating with the authorities because I was a minor at that point of time. Constantly, the authorities exchange their views.
2006, you were still a minor.
No. But the moment
2006, your mother asked for giving you employment. How could you be a minor?
No, 2006, I became.
Then,
Now,
for nearly 18 years.
my mother's application was pending. Kindly turns to the repetition once because I have crossed this hurdle many times before your lordship. Your lordship has put these questions to me and I have answered to this.
Yes.
Periodically, kindly turns to page 38 onwards. Because today, my lord, your lordship has said just. Shall I come back on Monday? As the first item.
Monday, we have already fixed one first item. We
Then
cannot. It will come. It will be taken up. Don't worry. It will not. We are telling you it will not. It will be taken up. Any other judgment? These two judgments, apart from these two judgments.
One judgment has been relied on your lordship regarding that related application, and I have also got only part of the state. And one judgment I have annexed to this with this petition. Antura Banerjee, when this is was a part the bench of which is stated. This is tendered kindly, may I read page 96. As indicated above, the committee found that the family needs appointment on compassionate ground of the petitioner and may be considered in this regard. The moment eligibility criteria incorporated under paragraph 6 of the CXP is found to have fulfilled or satisfied by the inquiry committee, and in fact, recommendation was made in this regard unless there is incriminating materials found in course of hearing by the said authority, and if there is no material to raise any doubt upon the recommendation of the inquiry committee, simply because the said authority formed another opinion cannot be the ground for rejection of the said application. And the court directed to give appointment was given. The inquiry committee has found me fit. The last line is, and found satisfactory in all respect towards recommending appointment to the post of constable. In spite of that, they are not given. What is my fault? My breadwinner died. My mother was practically, she was illiterate. 2 minor child. Remote village of Dokhin Dinajpur, they have not seen Kolkata. They have approached constantly in various forums. Kindly consider our predicament. A remote village 400 kilometers away from here. Where from they will come to this?
Therefore, these are the three judgments.
These are the judgments. But the division bench has said.
Division bench has said, and you have implemented.
No. They took place in 1992.
That judgment, whatever it says, is it binding on us?
Page 96.
It has got persuasive value because it is a division.
Persuasive value, it's a coordinate bench. We cannot go contrary to that judgment. Whether party or not, that is hardly material. That doesn't matter at all. Saying that does not improve your case by any way. Whether he is party, whether I'm a party, how does that matter? Immaterial. It has no bearing on anything.
The particular facts of a case.
Either it has a binding force or it doesn't. I need not be a party to the bench to say that it is binding.
The judgment of our Supreme Court, can you consider that? Our delay is concerned.
That we will consider. Therefore, we asked him whether he says he has gone through it. He will make out a case. He will make out a case. We don't know.
But if the respondents take so much of time to place me in that position.
That's
now
why.
they are asking the point of delay before the court when I have crossed all the hurdles and come before this court.
That is why we asked you since 2006 till 24.
But I keep time of 3-4 minutes. I will show all the documents. How the department has sent inter-departmental correspondence. Kindly allows me for 2 minutes.
No, we will see everything. We are not saying we are not in a rush. We will see anything because it can't be concluded. It cannot be concluded today. So therefore, we are not taking it up. We will hear you. Instead of Monday, we'll keep it on Tuesday. Then we can fix a time also. Tuesday, any matter is fixed.
Tuesday matter.
Tuesday, any matter is fixed. For further consideration, list on Tuesday.
December 2 p.m. 16 तारीख 2 p.m.
You cannot take up every case as a direct. We know it causes because we have been that side. But then I have been that side, I know. But then the bench has its limitations. We cannot open. We know. I have faced that for 2 decades.
OP.
It's not that I'm oblivious of what goes on. I know what goes on here. I know what goes on after leaving the court. I know everything. I've done it absolutely. Yes.
Item 17.
All right, not good. Long delay.
18.
No, respondents 6 and 7. Both have been served. They were earlier represented by an advocate. No. 6 and 7. What was provided? AC and audio. Financer. So what is the order under appeal?
There is no other specialty, no experience. But we got the specialty are employed by me. But in spite of that, there is no scope to enjoy the same facility.
But your RC says yes. Your registration certificate says yes.
Paid also. Initially, when the tax amount is the visa, then they paid that amount. But ultimately, when there is a huge amount of the tax has been imposed, they checked up, and therefore the understood that this facility is incorporated in the power total, and on the basis of
So
that,
you paid for how long? Your vehicle was purchased in 2014 and you paid till which year?
And when you come to page 26, tax amount 48, 660.
We are,
26, how much they are? 75 days.
oh, so that is why we must have directed for service. Where is the service? Page 4 of your affidavit of service. Where does it say that it has been served?
And subsequently they received a certificate.
Which page? Please show us. Till delivered where? This does not show received. Normally we have seen it says item received. There is no such. Doesn't appear to be. So many cases we have seen. I have seen that it says delivered to addressee. It does not say addressee also. Delivered on such and such date. Where? Back to the post office. Where? How do we know? Because until 3rd, it is still in Council House Street. After that, there is nothing. But how to accept this as valid service? It does not say the addressee, delivered on the addressee.
Page 7 redirected to Sakasana. 7 is redirected. What is the date? Date 6th, then come to 2nd Sakasana.
IDC, what is IDC? IDC is not the addressee. You see page, you have a copy. You see, this is what they are saying delivered. It's not on the addressee. That is 812. Just see what is the position up to date. So we are not taking that, you can revise it, yes, not today. Use for the state.
And number 19.
Time for